All right, my name is Sev Carlson. I serve on the International Committee for Mackerel International, and we'd like to welcome you all to a segment of our virtual annual general meeting that was scheduled for London this year, but now we're all participating from our homes and offices here in 2020. Today we have a panel of unique practice areas comprised of 3 lawyers from member firms in the United States. We have with us today Laura Baker from Foster Graham in Denver, Colorado. We have Jeff Misley at Sussman Shank in Portland, Oregon, and Andy Ryan with Sandberg Phoenix in St. Louis, Missouri. I think to start, if we could just go around the table, the virtual table that we have today, and if each of you could introduce yourselves and your unique practice area so that our audience can learn who you are and what you do. Laura, we'll start with you.
Sure. Good morning, and thank you for having me. My name is Laura Marks Baker. I am a trial attorney. I've been practicing in Denver, Colorado for the last 15 or so years in criminal trial work. The focus of my practice has traditionally been representing those who are accused of criminal activity, though over the years it has morphed into an ancillary Title IX practice that is a component of my criminal defense practice, and I represent both those accused and victims who themselves in a position of initiating Title IX cases.
Great, thanks, Laura, and we'll talk to you some more about that practice. Jeff, if you'll introduce yourself as well, that would be great.
Yes, thank you, and thank you for having me. My name is Jeff Misley. I'm with the Sussman Shank firm based in Portland, Oregon, and I may be the senior member of this panel. I've been practicing since 1985 with a big part of my practice is rights and insolvency cases, and I do a significant portion of my work involves agricultural law, agribusiness.
Wonderful. And Andy, you're up next.
All right. Thanks for having me, Sev, and hello to everyone. My name's Andy Ryan. I'm a lawyer at the Sandberg Phoenix and Von Gontard firm in St. Louis. My practice focuses on product liability defense litigation, and we handle pretty much a broad spectrum of product liability cases, from automotive and industrial equipment cases to pharmaceutical and medical device cases. So we handle just about anything that has to do with product liability. And what I'm going to talk a little bit about today is kind of a niche practice area that I've handled in the last few years, and that is with hunting tree stands that we see a lot of here in the Midwest and the South, but not so much out in your neck of the woods. So thanks again for having me. I look forward to sharing some of my thoughts on handling those types of cases.
Wonderful. Well, I guess I'll start with one question, and I'll start with Jeff, but I think that the question will also go to our other panelists. But Jeff, how did you first get started in this area of agricultural law?
Well, I grew up in a small farm in rural Oregon, really what we would call a hobby farm out here. My parents were teachers. My dad thought it was important that we grew up on a farm, and so he purchased a place, and that's where we grew up. But it did give me a good starting point in the area of agriculture. And when I started with Sussman Shank, it was in the mid '80s. There was a lot of distressed agricultural activities going on. At that point, Mount St. Helens had erupted, destroyed some crops. Interest rates were 10 to 15%, and farmers were struggling. And so the senior partners of the firm at that time, who were from the East Coast, said, "Jeff, you're a farm guy. You speak fluent farm. These cases are going to go to you." And that was kind of my introduction to agricultural law.
And Andy, how did you end up, I guess if you can describe for us, how did you end up becoming a tree stand lawyer, for lack of a better phrase?
Yeah, I don't know that there is a better phrase. It was by happenstance more than anything else. When I was an associate, after joining the firm, 15 or 16 years ago now, one of our named partners, Peter von Gontard, who's related to the Bush brewing family, if you can believe that, they own some property in the middle of St. Louis in an area where you can still have farms and farm animals. So they've got a huge plot of land smack dab in the middle of St. Louis, but they also have a lot of livestock on the property, including a buffalo, a longhorn steer. So because of the nature of where he lives, he is able to hunt, and he uses tree stands, and he's got several on his property. So by virtue of the fact that he uses tree stands, he started getting some of that type of work. And when I was an associate, he asked me to help on some of those things. And over the years, we've had a handful of those types of cases that have just kind of stemmed from Peter having used tree stands at his home. So kind of an interesting way to get involved in a particular area of law.
Great. And Laura, how did you end up moving from, I think really starting with the criminal defense practice into this Title IX practice?
So I still do criminal defense work predominantly. I found myself as the only young woman in the practice, being the second seat in a lot of sexual assault and sexual misconduct cases courtroom. And over time, what began to happen is that as an ancillary component of a criminal case where the client was accused of a sex assault, the client faced disciplinary action either at the university level or even at a secondary school level. And so I started to become versed in the issues of Title IX, starting back in 2011 with the Dear Colleague letter that really sort of defined at the time the way Title IX was working. And there weren't very many lawyers that happened to be focused on that niche practice. And so it really has become a companion of a practice that focuses predominantly on sex offenses, and specifically the Title IX work becomes sort of a parallel component of the criminal trial work that we do. And as the regulations have changed, my practice has become more national and less exclusively local. So here I am.
Wonderful, wonderful. So Laura, do you want to explain to us, what people should be on the lookout for? What, in my mind, it's that question of, for all of our viewers, they've met you now, what's kind of that snippet of advice of where they'd want to call you? I'm thinking about, I don't have kids in high school or college yet, but that's what kind of comes to mind as a parent of, well, hey, what if my kids get in trouble while they're at school? Even if there isn't, we'll say, a criminal action yet, or maybe there is no criminal action, but what if the dean's office calls and says they want my son or daughter to come to the dean's office on a non-academic matter?
Well, it's a great question, and I think all of us, whether you have friends who may. And so the first piece of advice that I would give anyone, not to presume when you've received contact, either from a university or even at a high school level, that you can walk in, particularly at 18 years old, and sufficiently establish your own rights, particularly under the federal guidelines, and know exactly what to do. The recommendation is to contact a lawyer, contact this group perhaps. We certainly do the work. There are other lawyers throughout the country that do the work. But if you get any form of notice from a school, or your clients or your friends or your families get any form of notice from a school that they are in trouble and being accused of something particularly related to sexual misconduct, before the person goes in to speak, contact an attorney. Don't presume that you can walk in and sort of talk your way out of it or work your way out of it. You need to have some legal advice before you try to address it on your own. And I think the other important piece of advice is, before your kids or clients' kids go off to school, have this discussion with them, that it's better to tell mom and dad if they think they're in trouble than to go in and try to handle a Title IX matter on their own, without contacting dad and then subsequently perhaps a lawyer.
That's some good advice. Laura, do you see any, I guess, for our audience, any big changes coming about? I mean, what's your, is this Title IX practice changing kind of as we speak?
Yes, absolutely. Within the last month and a half or so, the federal government, through the Trump administration, and specifically Betsy DeVos through the Department of Education, has done a very, very broad modification to the Title IX regulations. So under the Obama administration, the regulations had sort of fewer safeguards in terms of due process considerations, fewer requirements that look somewhat like a courtroom. Seb, do you want me to get into sort of the whole presentation now, or do you want me to just talk about sort of the general overview and wait to get into the broad topic area?
I think the general overview would be great. And Jeff, I think, that's a kind of an interesting segue. We obviously have Ms. DeVos and the Department of Education, just in their regulatory process, have made changes. But Jeff, are you seeing the potential, obviously with coronavirus, in terms of its impacts on agribusiness and your practice on the receivership on the agricultural side of the world?
Well, we're seeing a lot going on in agriculture right now. We're seeing a lot of agricultural receivership, but more currently we're seeing a sharp uptick in activity, of course, due to COVID-19. Yesterday, seafood processing plant on the coast reported 124 new cases of the virus. So we're seeing COVID-19 in agricultural enterprises showing up in the labor force, and that, of course, the virus has disrupted supply chains and pretty much everything in connection with agriculture. A good example of kind of what's happening right now is in January, we started a large potato case, and at the time, the price was the highest in years. Everything looked very favorable. And now 2 or 3 months later, every restaurant in America is closed, the schools are closed, no one's eating French fries, and they're giving away potatoes. So huge disruptions in agriculture, in addition to the usual problems that they have regarding labor, weather, everything else connected with agriculture.
Right. And Andy, for you, I mean, what's, how do your tree stand cases come about? I mean, is it a time of year where they pop up, hunting season? Obviously they probably stem from when people are going out, but what's the background on where these tree stand cases come from?
So yeah, they do happen during hunting season. So for us, that's, usually from November until about, I think it goes into January or February. I always remember the start date, but I'm not quite as clear on the ending date. We've got a long statute of limitations in Missouri, and it's 5 years. So we don't necessarily see cases pop up at any particular time of the year, but all the accidents are happening in the fall and in the early winter. So that's when we're seeing them. Most of the cases that we have are pretty significant injuries, which you can probably imagine that's going to be the case because most of these stands are a minimum of 15 feet high. So you've got people falling off them from pretty significant heights, which generally causes some issues when people fall from that height. We get injuries from shattered legs to shattered pelvises to head injuries to back injuries, you name it. So that's kind of what we see in terms of when the cases come in and what types of issues we have to handle in terms of injuries.
So Laura, going back to you, if you want to just give us an overview, for the audience, you can get into some of the details, and then we'll move to Jeff and Andy for some details on their practice areas. And Laura, I think you're still on mute.
Thank you. Okay. I wanted to start by talking about what is Title IX, talk just briefly about its origins, and then move into a discussion about how Title IX has changed and what we're seeing evolving in the Title IX arena now. So originally, Title IX was a federal law that was enacted in the 1970s, generally to address discrimination in universities, particularly in things like sports. Over the years, it has evolved into becoming something of a gender equity tool. But in the last decade or so, it has morphed into becoming sort of the guiding federal law on disciplinary actions within an educational institution. And it's that component of Title IX that I'm going to focus my presentation upon. The genesis of how we found ourselves in the position that we're in today with Title IX really, I think, began in 2011 with what's called the Dear Colleague Letter, which was a lengthy piece of guidance from the U.S. Department of Education requiring that universities conduct disciplinary investigations for allegations of sexual violence on campus. And specifically, and of import, federal funding was tied directly to university compliance with INE. So universities became required, in order to sustain their funding and keep their funding, to follow the guidance set in this Dear Colleague Letter. And that's really when we started to see investigations expand and universities take on the role of investigating sexual violence on campus. Now, whenever there's an investigation into an allegation of harassment or sexual assault, whether it's on a college campus or even in a secondary school like high schools, I've seen it go down as far as elementary school, Title IX process is generally initiated. And as I said before, as a practical matter, when you get notice that something like this is happening, or you have a client who calls you that says, I think that my client's kid is in trouble, what should I do? The first thing you have to advise a client is to contact a lawyer. So in terms of getting into the changes that have occurred in the Title IX area, which is really where I want to kind of focus my remarks today, with the new federal regulation that dropped, they've really done a complete overhaul. And the design, at least state the Department of Education, is to increase due process safeguards while assuring a fair and neutral process, both for victims of sexual violence as well as those who are accused. Now, it certainly has become something of a controversial area. We have critics who are quite concerned that where some of these new processes are required, it may chill the willingness of victims who have been traumatized to come forward and report what we are already concerned about are underreported sexual assaults on campus. Critics are concerned about the re-traumatization stigmatization of victims, and some of these new safeguards and regulations require significant resource for universities that already, and particularly right now, may be facing budget deficits for those universities or are already underfunded. What we've started to see with some of these regulations is that states' attorneys general have initiated different lawsuits, and I will talk briefly about that. Now, some of the proponents of the changes that we are going to get into feel quite strongly that when an allegation of sexual violence is made, be it university level or below, that accusation is often enough to be the catalyst to destroy the future of a young person and derail the progress that that person may make through the course of their life. And expulsion operates sometimes where a student off college campuses, that operates in many ways tantamount to a criminal conviction. The student who is accused no longer may have an opportunity to get a college degree, which will of course affect the future of that person's life, as well as the public scrutiny that comes now with social media and the internet that relate to that accusation. And proponents of these changes to the federal rules have concerns that traditionally there has been an approach that doesn't start with the presumption of innocence that we actually see in the criminal courts, but rather a wave of start by believing the victim, which sometimes can be at odds with our traditional presumption of innocence model. So, Sev, if I may, if you want me to kind of continue with my discussion, I'm going to talk about sort of how Title IX used to work and how we're seeing those changes come forward.
Yeah, that would be great, Laura. Thank you.
Okay. So it would take me 2 days to discuss all the nuances of Title IX, the new law, and the old law. So I want to focus on the major changes, and I will give the caveat for what all of this means. So I caution viewers to take my presentation today with a bit of a grain of salt because we haven't yet seen any litigation related to it. We're just starting to see some of that. But prior to new regulations, what was happening is when a student was accused at a university, most universities had what was called a single investigator. So an alleged victim would come forward to the university and say, I have been the victim of a sexual assault or some kind of sexual violence. And the university, through its Title IX coordinator, would often only have one person involved in the investigations. That person often, not always, not all schools were the same, but many times what we would see is that person was hired as a result of their history in victim advocacy. There were few required notice requirements. So for clients of mine who were accused, they would receive, for example, an email from the university saying, Jane Doe has accused you of sexual misconduct on November 20th of last year. We want you to come in tomorrow and tell us what your side of the story is. There was no federal guidance requiring the sharing of evidence in advance of questioning students. Once an allegation was made, an investigation was initiated based on claims where the university had perhaps gathered statements from victims, witnesses, but not required to tell the person accused what they were being confronted with. Likewise, regulations didn't require that an advocate have a substantial role. In other words, if I as a lawyer accompanied an accused party into a Title IX interview or investigative process, I was required as the lawyer to stay silent. All of the statements had to come through my client, which you can imagine, particularly when you do criminal defense work, as I do, that created a lot of concern about parallel criminal investigations and Fifth Amendment implications. When a student is being faced with the requirement that they comply immediately with the university investigation, knowing that there may also be a criminal investigation forthcoming, and having to decide, it's a bit of a Hobson's choice. Do I try to keep my position at the university by defending myself, where I may somehow implicate myself in terms of my Fifth Amendment considerations? The other big difference that we're going to talk about is that the Title IX process nationally, before these new regulations, didn't have a hearing requirement. Some universities throughout the country did conduct hearings, but as a general rule, there was no requirement that parties have an ability to go to a live hearing, conduct a cross-examination, address credibility concerns of complainants or even witnesses. And the standard of proof required for these university investigations was preponderance of the evidence, which meant that investigators who were the arbiters of sort of these disciplinary investigations were required to find that only more likely than not, the student accused may have done what he or she was being accused of. So that was sort of the backdrop of how these investigations were conducted. And universities were doing it with concerns about risk of loss of federal funding. So critics of the old system were often concerned that the university had little incentive to create a neutral or a fair playing field where it was easier just to cut a kid loose, expel that person, and not risk losing any federal funding as a result of the university decision. So now getting into the new regulations and some of the specific changes. The Obama guidance stated that college officials use that preponderance of the evidence standard. The 2020 regulations instead allow Title IX officials at colleges either to use that preponderance of the evidence standard or a more rigid or sort of higher standard of clear and convincing evidence, which of course requires a higher burden of proof. The new regulations have changed to some degree the jurisdiction of universities in being required to address acts of student violence on and off student campuses. So it used to be that universities had an understanding that their obligation was to conduct Title IX investigations anytime they had a circumstance come up on or off school grounds where one violence. We saw cases, for example, where students were on study abroad programs and universities were being tasked with investigating what may have happened in another country. Now, under these new federal regulations, colleges are only obligated to respond to reports that occurred off campus if the location is in use by an officially recognized student or institution organization, such as a recognized fraternity or sorority housing or athletic housing. Colleges must act upon complaints of misconduct that occur within an educational program or other events that are part of a university program related specifically to that university. But it allows for some discretion for colleges to make these decisions themselves. And I should say, as I'm talking about all of these changes to these regulations, they're required to be in effect by August 14th. And so what we're starting to see, at least in the groups that I am involved with in advising the legislature and state universities, that this is a very short window of time. Schools are dealing with budget problems and coronavirus problems, and also having to overhaul the way that universities handle these kind of disciplinary hearings. So Going back to some of the changes, and this is an important and criticized change by critics of the regulation change, is that the definition of sexual harassment has changed. It has become more narrow than previous guidance. Now, the regulations state that any unwelcome conduct that a reasonable person would find so severe, pervasive, and objectively offensible that it denies a person equal educational access is now the definition of the sexual misconduct under the Title IX umbrella. So that's different. That is a much more narrow definition of sexual violence. As universities are progressing into this process, they are no longer allowed to use what was once called a single investigator model. That means that it used to be that universities would have one person who really served as the judge and jury in the disciplinary process, tasked with investigating, adjudicating, and ultimately issuing the disciplinary sanction against respondents on behalf of the university. The regulations now require that universities have 3 separate positions to work through separate pieces of the Title IX complaint process. So now a Title IX coordinator cannot also be the investigator and the decision maker. Universities now have to have 3 people properly trained conducting. So you have a Title IX coordinator now who receives the report of the sexual misconduct, an investigator who gathers facts and interviews parties and witnesses, and a decision maker who will ultimately determine sanctions and remedies for parties. There's a lot of discussion about what that will look like in terms of the presentation of evidence and whether that decision maker has to be either a trained lawyer or a judge or an arbiter of some kind, because there are going to be legal issues that come up in the process. Likewise, the regulations now have changed where they used to require a 60-day time frame as a guideline to complete the investigative process and the disciplinary process. Now the regulations are changed that require it be reasonably prompt for the carrying out of each step. So the criticism of that change is, of course, students who are in a difficult position of being involved in this investigative process are concerned about it being drawn out for a period of time, distracting their focus at the university level. On the other side of that, proponents of this rigid timeframe standard who have other Fifth Amendment concerns may be able to sort of get their arms around what may be going on in a criminal complaint, while also having the time to assess and analyze what's going on with regard to the accusation itself at the university. One of the biggest changes to the federal law, and I know I am moving very quickly through this, as I said, this could take me days, but one of the biggest changes is that now universities are required to hold a live hearing and permit cross-examination. At least in Colorado, where I practice, one university out of the many in Colorado that was allowing for a live hearing. So most of the time, and in many states, you were not permitted to cross-examine the bona fides of the allegations or the accuser in person. In other words, you would go in and do an interview, and the investigator would compare the credibility of the statements that he or she heard as part of the interview process without the ability to conduct cross-examination. Now the new federal regulations require that colleges provide the evidence that the investigator has gathered and do that within 10 days of a scheduled live hearing. That was never in effect before, at least as a federal law. Now you have the ability, particularly as the respondent in the hearing, to see the evidence that has been compiled against you, and then go to what will probably be virtual hearings where lawyers or advocates on behalf of both parties now must conduct the hearing themselves. So the regulations safeguard against a victim and an accused party cross-examining each other by requiring that advocates have a predominant role in the process, which again is very different than the way that it used to work. Also, universities are required to record the hearings and to keep a transcript or a recording in college records for 7 years. So that, I will just tell you, is creating some consternation for universities in terms of how they're going to maintain and control what is effectively a record that a court might keep and how they are required to do that. So, Seb, I'm not sure what, I wasn't keeping track of my time. I'm happy to get into some case law and talk about some of the sea changes that we've seen historically in terms of why this law has changed and how we expect it to look. But I don't want to, I could carry on for days.
Yeah, Laura, I think we're going to move along, even though I'm fascinated by it, and I think our viewers will find it that way. And I think the takeaway is, for people who have any follow-up questions, they should reach out to you at Foster Graham in Denver. So thank you for that. Very interesting, and we will have some time for just some kind
Absolutely.
of closing comments. But I think, Jeff, we'll move on to you. I'm curious as to how you developed this practice that focused on agriculture, and I know you and some of your colleagues at Sussman Schenck do bankruptcy, insolvency, receivership work, and is that really a large part of your practice that you've been able to develop over the years?
Yes, so thanks, Seth. Yes, it is a large part of our practice, and we have a strong creditors' rights group, and the firm has a long history in that area. When we started in the 80s, or when we started in practice, I mentioned that there were a lot of farmers and ranchers in trouble then. At that time, the remedy was to file them in Chapter 11 and reorganize those entities, and a lot of more smaller farms, and we were very successful in reorganizing their financial affairs. Those farms and clients and ranchers and egg producers, in many cases, remained our clients, and we remained as general counsel, assisting them over the years. And over time, their operations and organizations continued to grow and be very successful. So it helped us to kind of expand our practice in agriculture, and it really involved all agricultural products, from berry farms to onion farms, cattle ranchers, hazelnuts, all the different products that Oregon and Washington producers produce. At the same time, in my practice, I started representing food distributors and suppliers, and so that practice continued to evolve over the years. So that led us into other areas of practice, representing the suppliers, processors, and then later cooperatives. So all of that combined, and it happened over a long period of time, but all of that combined to give us a solid footprint in the farm and ranch communities in Oregon and Washington, and more recently in Idaho. So, and part of that practice, or really a sub area of that practice, is the agricultural receivership cases, where we've represented court-appointed receivers and fiduciaries. And for the viewers who may not be well versed in receivership law has been around for about 100 years at least, but it's never really been codified well or defined well at the state level. And I think it was about 15 years ago, the state of Washington enacted a receivership statute, which kind of provided the first roadmap of how can we wind down these companies in trouble, or how can we restructure them outside of bankruptcy. Oregon followed it just a few years ago, enacted its receivership code, and we're seeing now a big push and a movement from Chapter 11 alternatives to state court receiverships, which are generally more cost effective and less burdensome. Chapter 11 over the years has become, it works in the right cases, but it's very expensive. It's very, very difficult process. And I think practitioners have found that moving towards receivership proceedings has been a really great alternative to that. So just in the last few years, we've had a number of agricultural receiverships, which involve potato farms, berry farms, cattle farms, dairy. There's been dairy receiverships in Oregon, and those types of cases, the receiver who is appointed, the case is commenced by a secured creditor after a default in a loan. The lender asks for a court-appointed fiduciary, and that fiduciary acts as a trustee or court-appointed fiduciary for the benefit of all creditors. So what really happens in these receivership cases, they're really business cases within a piece of litigation. There's so the receiver is charged with administering the assets. That could be running operations. It could also be, oftentimes it involves the sale of assets. So you can be involved with the sale of farm property, equipment, cattle, just lots of activity within the receivership case.
Yeah, and Jeff, I guess one kind of follow-up question, are there any particular regulations, guidelines, or I'll even say just basic rules of practice that you need to be cognizant of in the ag business versus another business that might be in receivership?
Well, the ag business is so broad and diverse, it can move you into all sorts of different areas, subspecialties of law. It can be employment law because you can't get your laborers up here from Mexico. You can have water law issues, which is a big issue. You can have supply chain issues. Last year it was tariffs. This year it's COVID-19. So you get into all the food-related industry. The industry trends take you into issues like certification, sustainability, those kind of things. So it's really a mix. In the actual receivership law, it can be either state law, such as an Oregon receivership or Washington, or you can also institute a federal receivership, which you don't see as often, but we have represented receivers in large receivership cases. North Pacific Lumber was one we did about 10 years ago, and it had 100 inventory in 150 locations across the nation, and we work with the receiver to kind of bring those down. So one of the interesting things I think about the insolvency law is you deal not only with just the regulations regarding receivership, or in bankruptcy or outside of bankruptcy, but you also deal with a lot of state and federal law issues. For example, in the food distribution area, we frequently get involved with PACA, the Perishable Agricultural Commodities Act. We get involved with the statutory ag lien claims on behalf of producers and the suppliers who provide the input and the economics that go into making the crop. So it's really a very, very broad practice.
And Jeff, do you see, what are the opportunities coming up in terms of marketing this practice and where this practice may be going on a going forward basis? Where do you see things developing and where the opportunities are?
Well, there's certainly tremendous marketing opportunities in agriculture, and you take Oregon, which is a relatively small state, and in Oregon we have close to 40,000 farms, ranching operations. Oregon produces and exports 220 separate agricultural products, so it's just a big footprint of our economy. Signature crops include hazelnuts, grass seed, wheat, berries, fruit, seafood, and on and on. So there's just a huge opportunities there. And of course, as a result of the pandemic, we're seeing more distressed opportunities. And so again, the agricultural receivership seems to be provide a good opportunity, a good alternative to more traditional insolvency proceedings. Outside of the creditors' rights areas, there's also great opportunities and business potential for marketing. The average age of a farmer in Oregon, and it's probably the same across the nation, is about 60 years old, which I used to think was pretty old, and I don't think it's very old anymore. And so there's going to be a tremendous shift in ownership, and we're just in the beginning stages of that. Large portions of the agriculture is going to be shifting to new ownership within the next 5 or 10 years. So there's a lot of opportunities. People are seeking us out now for ag succession planning. How do we move the farm and the farming operations to the next generation? We're restructuring companies, not in a creditors' rights way, but in a business restructuring to make sure that the current operations can be moved to the next generation. And so there's great opportunities there as well. So lots of opportunities in agriculture.
Great, thank you, Jeff. Again, these unique practice areas that I think this is a wonderful opportunity to highlight for our other members to learn about what everyone does, and that we have these resources available for members to call each one of you. So Andy, let's go back to you in St. Louis. Can you talk about tree stands? I mean, who are the players in the industry? What types of regulations do you guys face? And then kind of talk about why these cases are unusual or different from your other defense work that you do on the civil side.
Sure. So there's an interesting cast of characters, so to speak, across this industry. A lot of the suppliers do not do their own manufacturing. Most of them will outsource their manufacturing to China, which creates its own concerns from a litigation standpoint, because when jurors hear that products getting manufactured in China, that tends to be a strike against us in litigating cases. But the long and short of it is the suppliers are outsourcing the construction of these products to China because they're able to construct them cheaper and sell them cheaper over here. They go through, for the most part, the big box stores. So as far as distributors are concerned, the suppliers will work through stores like Bass Pro, Cabela's, Buckeye, you name it. Those are typically going to be the distributors that come into play. So we've got this whole stream of commerce that's typically going to start with a Chinese manufacturer, distributing through a supplier in the United States that then is going to go through one of these big box stores. We run into issues litigating these cases when you have the Chinese manufacturers, not only from the perspective that you kind of get some jurors tend to think negatively about that, but these Chinese manufacturers are typically going to leave the suppliers in the United States on the hook to litigate these on their own. The plaintiffs' lawyers aren't interested in going to China to sue any of these Chinese companies. The Chinese companies really don't care if they get a verdict against them in the United States, because, what are you going to do to enforce it? So usually what we're left with is defending the suppliers or the big box stores, but more often than not, it's the suppliers. And what that creates is some difficulty in going through the design and manufacturing process, because we still have to find a way to get information in China over here in order to defend the case, in order to defend the product, in order to defend the manufacturing process. So that creates some difficulty with us in trying to get these Chinese manufacturers to cooperate, to at least allow us to defend the suppliers over here, even if the manufacturer is not going to be in the case. It's important when we defend these cases to make sure that the suppliers we are working for have good quality assurance programs in place. Even though the manufacturers are in China, most of the jurors in the United States are going to look to our suppliers to have an appropriate quality assurance program in place that they can then send over to China to make sure there aren't any manufacturing defects throughout the construction process. So that's one of the things we always like to make sure our suppliers have, is some good quality assurance programs in place that will help us defend the cases better, even without the manufacturer in at trial. The industry is regulated, not to a significant degree, but there is a group called the Tree Stand Manufacturers Association. That most of these suppliers have joined, and the Tree Stand Manufacturers Association has implemented standards throughout the years that are applicable to tree stands. There's various testing standards that are that the participants in the association have to observe. There's standards that pertain to safety devices. There's standards that pertain to warnings that are supposed to be accompanying these products. The big standards that we look at in defending these cases, and the ones we're most concerned with, are the testing for stability and for repetitive loads. So in other words, there is testing to make sure these stands are strong enough to hold what is typically up to 400 pounds of weight. And there's various testing labs throughout the country that perform this testing. The loads that they're tested to are typically up to 800 pounds. The repetitive load testing is typically something done to 10,000 cycles. So you're dealing with loads and usages that are way beyond what's required in the real world. Those all help us defend these cases. We get these laboratories on board. They do a very good job in their testing. They make sure these stands hold up to real world circumstances. And the fact that we have these standards in place, something that jurors tend to like, it usually offsets the negative impact from having these Chinese manufacturers by being able to show that, hey, even though these things are being made in China, we still have standards in the United States that our people are required to comply with, and are required to comply with on a fairly regular basis. This isn't something that's just done once and then a stand's allowed to stay on the market for as long as people will buy it. This testing's done at least every couple of years to make sure the design still stays such that it's going to be safe for people to use in real world circumstances. So those are some of the things that are helpful. Those are the kind of the specialties that we've developed over the years, knowing what the standards are, what quality assurance program needs to be in place, what type of experts we need to use in terms of metallurgists, things like that. And that's kind of where things have developed in our tree stand manufacturing practices. We've developed expertise in all those areas so we can defend the suppliers and the box stores a little bit better than other attorneys might be able to.
Great, thanks, Andy. So, Andy, is your practice mostly defending in litigation, or is it also does it also include advising suppliers as to what standards they want to have in place, what protocols they want to have in place before they manufacture a product?
Yeah, ours is, we're limited to defending cases. And the reason we do that is we've decided that we don't want to be involved so much in advising suppliers on various regulations, on warnings, things like that, because we think that could come back to bite us if we, have a case where we're asked to defend one of these suppliers in litigation. If the other side finds out we're involved in actually developing these warnings, developing any of the quality assurance programs, things like that, that there's some sort of tension there in being able to defend them effectively when the other side is able to point out that we're involved in developing all these ancillary issues with the suppliers. We typically refer people off to various regulatory practices and groups we know throughout the country. So to the extent there are people in Mackerel that are involved in providing regulatory advice to manufacturers, that's certainly something that, in the course of our practice, when we have clients asking our advice on what types of warnings to provide, what type of regulatory compliance they need to make sure they meet. That's certainly a referral source, I think, to any of our practice members who do provide that kind of advice to clients.
Well, that's worth noting. Thanks, Andy. So I think we're coming up probably on an hour. So I think we'll go around the virtual table again quickly, and just if there are any final takeaway points you want to leave the audience to remember you and your firms, not only in these practice areas, but even more broadly, just as an opportunity to let the members of Mackerel International throughout the world know, again, who you are and what your takeaway points are. I want to thank everyone for your time today. I found each of your presentations interesting. So Laura, we'll start with you on a little closing summary, then Jeff, and then we'll leave it to Andy.
Well, thanks again. My name is Laura Marks Baker. I'm at Foster Graham Milstein and Kalisher in Denver, Colorado. And if you have clients, friends, or family anywhere in the country that find accused of a disciplinary process at a university level, certainly it's the kind of work we do, and advise that client that they can't sort of rush in and handle it themselves or try to handle it with a lawyer who perhaps doesn't have the background on Title IX to know all of the changes and all of the nuances of the process.
Thanks, Laura. How about you, Jeff? Would any closing comments?
No, like Laura, I would thank you for having us, and thanks to all the viewers. Again, I would just emphasize that, you know, within the context within the subject of agriculture, it is so broad that there's just tremendous opportunity for legal practitioners. And again, even though our experience historically started with the creditor's rights, that's great. It's a great training ground. It's a great beginning because it puts you in the eye of the storm, and it leads to healthy transactions such as mergers and acquisitions, real estate transactions. And over the years, we've represented, you know, again, farmers, ranchers, landlords, statutory lien claimants. It's just such a broad area of practice that it's just, I really encourage firms to look in that area. There's tremendous marketing and business development opportunities, not just in Oregon and Pacific Northwest, but everywhere, because there's definitely a need, and it's a great area of practice to be involved in.
Great, thank you, Jeff. And Andy, any last words from you?
Yeah, not much to add beyond, again, thanking you for the opportunity to speak with everybody in the group. It's unfortunate that we weren't able to see everyone in person this year, but at least it's nice to be able to stay in touch, and that we've got something like Zoom that enables us to keep in touch. But just to remind people that even though this tree stand litigation that I talked about is a pretty niche practice, to just remind everyone that our firm handles all sorts of product liability cases, and then we get into business litigation, insurance defense litigation, insurance coverage matters here in Missouri, as well as into Kansas and Southern Illinois. So keep us in mind if you have anything in our neck of the woods to come up, or that comes up that you are looking for help on, and we are happy to oblige in any way we can. So again, thanks, Sev, and thanks to everybody at Mackerel for the opportunity to talk to them.
And I'd just like to thank all three of you again. You all come from very active and important firms to the network. We appreciate you giving your time. And just to remind everyone, we have Laura in Denver, Jeff in Oregon, and Andy in Missouri. Three great resources. So we hope that you get in touch with them should you need anything. And thank you all again for participating today.